what I can do maybe to streamline this is cover just a few that come up with real regularity. So one thing that comes up is litigation over claims. So when the debtor prepares and files a Chapter 11 petition, the debtor will include in that petition a list of all the creditors and a description of the kind of debt involved and a dollar amount. Now, if a creditor looks at that and says, I agree, that looks fine, the creditor doesn't have to take any action. But if the creditor disagrees with the way the debt has been scheduled or finds out about the bankruptcy and wasn't scheduled at all, the creditor can file a claim, a proof of claim in the case. And that then becomes the allowed claim unless the debtor challenges the validity of the claim. That's a kind of litigation that comes on, a claims objection. And the idea there is the debtor is saying, wait a minute, this is not right. This is an incorrect claim. Perhaps it's inflated. Perhaps it shouldn't be allowed because it is barred by the statute of limitations. Perhaps it's duplicative of another claim, and I've had all three of those and other grounds for challenging the legitimacy of a claim. So that leads to litigation. Another type of thing that comes up with some regularity is an avoidance action. There are two main avoidance actions in Chapter 11. Now, in these actions, the debtor prosecutes the lawsuit. In other chapters, it's the trustee appointed by the court who does it. But in a Chapter 11, the debtor serves as a quasi-trustee called the debtor in possession and has most of the rights that a trustee in another chapter has. So what is an avoidance action? Well, it's an undoing of something. It's a somewhat unusual usage of the word avoid. It means to, in essence, render null and void. And there are two main avoidance actions. One is an avoidance of a preference. The other is an avoidance of a fraudulent transfer. So a preference involves payments to a creditor prior to filing the bankruptcy case that give that creditor better treatment than it would normally get in the bankruptcy case. And to understand this, just think that there are two big goals in bankruptcy. One, to give the debtor a fresh financial start, and the other, to make sure that all similarly situated creditors are treated the same, equally and fairly. So if a debtor starts shoveling money at a creditor in anticipation of bankruptcy, that is preferring that creditor to other creditors. And that has to be undone or avoided in a lawsuit, a special kind of a lawsuit called an adversary proceeding. Another type of avoidance action that I just mentioned is a fraudulent transfer, where the debtor has transferred assets, perhaps to shield them from the legitimate depredations of creditors, or without getting a reasonably equivalent value in exchange for the transfer. In the Chapter 11, those have to be undone and the assets recovered, and they go into the bankruptcy estate, similarly with the preferences, and they are there available to pay creditors. And maybe it helps if you want to sort of think on a higher level. Prior to filing a bankruptcy case, the debtor has assets and the debtor has debts. When the debtor files the petition, the assets go into a bankruptcy estate and the debts become claims against that estate. So if there's been a preference, it's taken money out of the estate and that has to be recovered and put back into the estate. And if there's been a fraudulent transfer, that's taking an asset out of the estate and it has to be put back into the estate. So those are fairly common types of litigation that come up. Now another, this is more in a personal Chapter 11 rather than a business Chapter 11, is a challenge to the discharge of a particular debt. So in a Chapter 11, for an individual debtor, not all debts are dischargeable. The non-dischargeable debts are the same as those that are non-dischargeable in a Chapter 7 bankruptcy. So if the debtor, for example, incurred debt fairly shortly before filing the bankruptcy case, a creditor might say, hey, wait a minute, you incurred this through fraud because you knew you were going to file for bankruptcy protection, and therefore this debt shouldn't be discharged. The creditor saying that isn't going to do anything at all. The creditor has to convince the bankruptcy judge that that debt should not be discharged as part of the overall Chapter 11 discharge. And the way the creditor challenges the discharge of the debt is through litigation, through an adversary proceeding. Similarly, if the debtor is engaged in willful and malicious harm to a person or property, that debt will be discharged unless the creditor successfully challenges it. Same thing using an adversary proceeding, or the debtor's breached a fiduciary duty to someone. That debt will be discharged unless the creditor successfully challenges the discharge of the debt. Those are the primary types of litigation that come up in a Chapter 11 case, but there are others. Sometimes after the plan has been propounded, but before the creditors have had a chance to vote on it, a creditor might say, hey, wait a minute, this plan isn't going to work. It's not fair. It doesn't satisfy these particular statutory requirements that a Chapter 11 plan must satisfy. Well, how does the creditor challenge? Through an objection to confirmation. And of course, if it turns out that insufficient votes come in order to get the plan confirmed, that can lead to litigation over determining whether the debtor gets a chance to go back to the drawing board, or the case should just be converted to Chapter 7 or maybe dismissed. In any event, to answer your question, the reasons are myriad, and it's hard to give a simple shopping list of all the reasons that give rise to litigation in bankruptcy. But the idea with this answer was more just to give a flavor of what's going on rather than a detailed disquisition.